Good afternoon, everyone. I'm pleased to welcome all of you to the joint EdRed Franczek webinar on why you need to get so prepared for SOPPA now, during which we'll be discussing the ins and outs of the Illinois Student Online Personal Protection Act, or SOPPA. I'm Sarah Hartwick. I serve as the Executive Director of EdRed, and I'm pleased to introduce our panelists today, Don Tufano, Director of Technology and Innovation at Riverside School District 96, Franczek partner Nicki Bazer.
Hi, everyone.
And Franczek partner Jackie Wernz.
Hi, everybody.
As everyone likely knows, SOPPA governs and protects the privacy and security of data about students when it's collected by educational technology companies. The General Assembly made significant amendments to the law, which go into effect July of 2021. And because of the complexities of the new requirements, districts must act now to ensure that they will be in compliance by next year. Our goal for this webinar is to give you a roadmap of the new requirements and to discuss practical ways to come into compliance. We will try to hit all the high points throughout this webinar. If you have any questions, please use the Q&A function within Zoom, and we'll try to get to all your questions. If we don't, we make sure we leave time at the end to cover anything that was missed. So without further ado, let's begin. Jackie, can you start us off with your thoughts on the importance of student data privacy generally and how SOPPA fits into the larger scheme of student records and privacy protections?
Oh, I think Jackie may be frozen, so I'll just jump in until she's ready. Oh, Jackie, there you go.
Oh, sorry about that, everyone. I'm not sure what's going on with my internet. Apparently it's unstable. I think I'm unstable these days too, as I'm sure many of you are as well, but hopefully it will get back to normal. But so I think the question was to talk about kind of why is student data privacy why is it so important in general, and sort of how does SOPPA fit into the scheme? So student data privacy is not something that we've been dealing with that's new. We have been thinking about this for a really long time because basically, you know, the federal and state laws, FERPA and ISRA, that govern student records have been around for a very long time, even before all of this technology was here. And so once we did start using technology, and that technology involved the sharing of student records, it was sort of automatically an issue that, that we started thinking about. So we have been trying to figure out how tech and FERPA and ISRA fit together for a long time. And for most of that time, we didn't have a law that explicitly addressed student data privacy online or on technological apps. Instead, we were using FERPA and ISRA, which are general laws that were created to deal with papers in drawers. We were using those and we were sort of superimposing them into the realm of technology. We do have some federal laws that already started to touch on technology a little bit more, even before SOPPA came along. So for instance, COPPA, which I actually prefer to call COPA because I just like to think that I'm in Copacabana, but I think it is COPPA. My husband works for the FTC and he assures me that that is the correct pronunciation. But so COPPA is a law that has for a long time said that if you're collecting certain information about children who are under the age of 13, that you have to get parental consent before you do so, and that schools have in some circumstances the ability to provide consent on behalf of parents when they have relationships with vendors. So there's also the Ppra, which is just an amendment to FERPA that addressed collection of student information through surveys, and so it could apply in the technology realm as well. And you know, there's just a wealth of federal laws that, in addition to our student record laws, do sometimes touch upon student data and sharing of student data through technology in the school environment. But SOPPA you know, is really the law that for the first time for the state of Illinois comes in and said that there were requirements with respect to student data privacy online. So I hope that gives you a little bit of background, and I'm sure we'll get into a little bit more meat of what these particular laws require and don't require as we're going through.
Well, thank you, Jackie. So now let's drill into the law. Nicki, can you give us a quick refresher on what SOPPA requires now?
Yeah, absolutely. So everybody out there should know that SOPPA is currently in effect. Most of what we're going to be talking about on this webinar is the amendments to SOPPA that go into effect in July of 2021. But there are current provisions of SOPPA that are in effect. Essentially, SOPPA, what it does is it governs companies that operate websites, online services, online apps, mobile apps, and whose site, service, or applications are being used for K-12 purposes and were designed or marketed for K-12 purposes. So the idea is that if you're using education technology within your school districts, likely those vendors that you're contracting with are covered by SOPPA. And what you're really looking at with SOPPA in terms of covered information, student information, is information that's either created or provided by parents or students, or information that is gathered by these applications or these sites. And there's a number of prohibitions. This law prohibits operators, or what we call operators, these companies, from engaging in targeted or advertising or marketing, creating a profile on a student, selling or renting student information, and disclosing this information other than under very limited circumstances to others, to third parties. Also, it requires operators to have reasonable security measures for student information, to delete student information when requested to do so by the school district, and to publish a privacy policy that really outlines all of their privacy provisions. The current law applies to both public and non-public schools, but I do want to note that the amendments that we are going to talk about today do not apply to non-public schools. They have essentially been exempted out of those provisions explicitly in the new provisions. The only other piece of information that might be interesting is that SOPPA is enforced through the Attorney General's office, through complaints, through their authority. I'm not aware of too many complaints that have been filed at the AG's office, but as the amendments are going to be far more robust, we'll start to see probably some enforcement activity on that front.
Well, thank you. So now let's move onto the amendments and just spend a quick minute to discuss how we got there and the new changes. And so, you know, this, as Jackie kind of mentioned, this discussion began over 10 years ago of how to improve SOPPA and ISRA, or create SOPPA and ISRA, and in this new world. And honestly, even just 10 years ago, even just a year ago, the environment is so different for schools in terms of the educational technology companies and the apps that teachers are using. And so the legislature really sought to try to limit the use of student data and how it's shared and how it's used. And some of the initial drafts were extremely problematic. While all legislation, I like to say most legislation, is very well intentioned, had some pretty significant negative impact. Even one version at one point limited the state board's ability to calculate general state aid. You know, but the legislators were just coming from a point to make sure that the student data that's collected by schools are used to improve student learning and outcomes. And so the discussions, the negotiations, both formal and informal over the last couple of years related to these specific amendments, were really how to allow that student data to be used by districts, again, to improve student learning and student outcomes, but also have some necessary protections. The recent General Assembly discussions, as it also relates to these new amendments, were really focused on transparency and parent information so that the parents are aware of the technology that's being used by the district and the teachers and why it's being used and the purpose, and as well as transparency when it comes to those contracts that districts are signing on to with various companies. So let's dig into those new amendments. Jackie, why don't you tell us about the new requirements related to data sharing agreements?
Okay, so I will first start off by saying that here at Franczek, for those of you who have worked with Nicki and me over the years, you know that we have always recommended that districts use a data sharing agreement. We always had an addendum, maybe not always, but at least since Nicki and I started working on these things, we have had an addendum that we suggested that that schools use with their vendors just as a matter of course. So for many of you, that general idea may not be new, but what is new under this, this version of SOPPA is that it is now mandated by law, and that there also have to be a number of very specific things that are in the data sharing agreement. And again, I think the vast majority of these were already in our data sharing agreement, but we have made tweaks to that document so that they do come into full compliance. But so the types of things that are required to be included in the data sharing agreement at this point under the new SOPPA law are things like a listing of the types of information or the categories of information, student record information that will be shared with the operator. There also is a requirement that the operator is to say overtly that the operator is acting as a school official with a legitimate educational interest, and that they otherwise meet all of the requirements that under ISRA and FERPA are necessary for sharing of student data without parental consent. That does not mean that these operators are becoming your agent, or that because you're exercising the sufficient control over them that you somehow are becoming responsible for everything that they're doing. But the idea is that you're going to have this required information in the agreement so that it's clear to the world that you exercise the control over the data that is required to share that data with the vendor. There are also specific requirements with respect to what you have to do in the case of a breach of information. So there's very detailed steps that are required to be in the contract there. And there are other provisions that require, for instance, notification of breach or deletion of information within a certain amount of time at the end of an agreement. And then there is also required that not only do you post the written agreement on your website, but that you also include language in the agreement that indicates that you're required to do so. So there are, again, a number of specific things. That's not a completely full list, but the idea here is that for the first time, we have a legal requirement in Illinois that there be specific things in the agreement. And another thing to keep in mind too is that you'll see if you use our addendum that there are other things that should be in the agreement even if they're not required by law. So for instance, if I am required to post my agreement on the website as a school district, I am not going to agree to a very strong confidentiality requirement, which I see all the time when I'm negotiating contracts. So you'll note again that a good addendum is going to not just have the bare minimum of what is required in the law, but it's also going to take additional steps that we commonly see that need to be addressed in agreements in order to comply with those requirements.
So Don, what are the practical ways that districts can manage this new agreement requirement?
Well, what we've done, and I started working with Nicki probably about as soon as the law was passed, reached out to say we need to get our addendum updated. And I just really wanted to break the addendum up into two components, non-negotiable and then negotiable components. Given that it's, there's still a decent amount of time before the law goes into effect, is to be able to contact those operators and know in advance whether or not they're going to or are planning to be able to agree to those terms. What we don't want to be in the position of is having to replace services that, in a short amount of time. If we know that somebody, operator is not going to be able to comply, then there's a very good chance that we need to find a replacement for that operator.
Yeah, one thing I would just add to, a couple things. The first is, and I know Dawn's looking out for this as well, which is that some of districts are going to be entering into multi-year agreements now with their larger tech vendors. So their student operating systems where you might have a 3 or 5 year agreement. For those agreements, you're going to want to take a look, because even though right now SOPPA, these amendments are not in effect, if the agreement is going to run over the implementation date, then you're going to want to make sure that these provisions are covered. I do hope and expect that we are going to see more vendors being willing to adopt our data addendums, because if they want to do business in Illinois, and we are actually sort of not on the cutting edge of this, you know, there are a number of other states, I think New York and California most sort of, you know, I think are most well known, Louisiana, some other states have really robust data privacy laws already, which require addendums or agreements or parent bills of rights. And so I think that companies are starting to get used to these. Every once in a while I hit a company that just seems to be completely unaware of sort of the student privacy realm, but hopefully we will start to see a little bit more negotiating power on the part of districts, because these provisions are now required by law.
Yeah, and one thing to keep in mind is the way we've been coming up with, frankly, the way that we came up with and realized we were going to do a new addendum was because we had a very cutting edge client, Dawn, reach out to say, you know, we want an addendum now because we want to start working on this now. And so we have been, for many of you who rely on us regularly to do your contract negotiations for you, we have been, I think you would all be able to report if you were here, letting you know that, hey, this contract is actually still going to be in effect next year. And so you should be using this addendum, or you should be addressing these issues. If you regularly do your reviews in-house, which many, many people do and do very well, you need to make sure that you're thinking about whether or not that contract is going to still be in effect, and making sure that you're taking the necessary steps if it is.
So let's move on to the posting requirement. I know this is very concerning for schools. So Nicki, can you take us through that, please?
Yeah, absolutely. And this, I think, is the sort of the provision that strikes the most sort of uncomfortableness, fear, terror, you know, blind panic. I'm not sure where you all are at on this. I know there are other panic moments right now, so maybe this has been put on the back burner, but this is probably one of the more onerous requirements of the amendments, along with the data agreements. Again, we have always felt that data agreements are a good idea, so I think a lot of you guys are already doing that. This, I think, is going to be brand new, and Dawn, I know, is going to talk with us a little bit about implementation, because I think this is going to be a key issue. Jackie mentioned the requirement to post the agreements. It's that and more. So the first thing is you have to post and maintain on your website an explanation of all data elements collected and disclosed. And you need in that posting to describe how the district uses the data, to whom or what entities it discloses, and for what purpose. As Jackie said, you have to post both a list of all the operators that you have written agreements with, and the agreements themselves. In fact, the agreements have to be posted within 10 days of signing them. And there are some provisions that you can redact from the agreements, but for the most part, those have to be posted in full. And you also have to list, along with the operators, all of the subcontractors for each operator to whom covered information may be disclosed. And this becomes quite complicated with a lot of your smaller education technology vendors, because most of them do not host their own sites. They have a cloud service provider with whom they contract, and so there may be a subcontractor relationship there in which data is exchanged, and so you're going to need to sort of drill down on that as well. You also need to post on your website a description of you know, how parents can inspect and review, you know, what the information is that's being shared, how to make requests for how parents can request copies, how they can correct factual inaccuracies. Some of you guys will recognize some of these things from, you know, your ISRA requirements in terms of how do parents access the data. So you need to notify parents of those processes. And then a list of any breaches. So if there is a breach that occurs that meets the definition under the law, it impacts a certain percentage of your students, then you need to list the number of students that were affected, the date or estimated date of the breach, and the name of the operator. So a lot of heavy duty posting requirements. All of these pieces of information must be updated twice a year. So within 30 days of the fiscal year, beginning of the fiscal year, and 30 days at the start of the calendar year, again, with the posting requirement intermittently of anytime you enter into agreement has to be posted within 10 days. Now, I'm really excited for Dawn to be talking about this issue because I actually think that Dawn's technology and innovation website as part of the Riverside 96 is one of the best I've seen in terms of giving parents really clear information about how data is used and collected. So, you know, I know that these issues are going to be sort of forefront in his mind as well.
Yeah, with the posting requirement, well, with the new law, obviously, it's creating a lot of overhead for the tech departments across the state. There's a lot of extra work to be done, and very likely not necessarily the additional staff to support the extra work. So anytime you can look to a contracted service or something to assist with that, which is what we're doing. If anyone is currently using education frameworks and privacy product, if you already use them and you've ever interacted or spoken with their CEO, Jim Onstadt, he's very much in tune with what is going on with the changes in laws. They are a national company and they've made changes to their services based on the New York laws. And so in having conversations with him, what they will be doing for Illinois is making it so that their service can also then host a public-facing website that you can use as a repository for contracts, where you will be able to list all that information. And a lot of that legwork they will actually be doing for districts when it comes to, well, what information are these sites using, et cetera. And so that's definitely going to be, that's the direction that we're going for a repository, a way to organize the information for on the public side.
So, Jackie, we know a major concern of districts and parents is the safety of the student data and what happens if that safety is compromised. So what are the new requirements related to security in a data breach?
Yeah, so this really is a significant concern for parents and communities. I know that for myself as a parent, it is definitely something that I think about. So again, we have always recommended strong contract language on breach in our agreements that we negotiate for clients and in our previous addendum. But there are a number of specific requirements that are in the revisions to SOPPA that are important to know. So first of all, an operator has to notify the district as soon as possible, but no later than 30 calendar days after a breach has occurred. So that's really important. This gives the district the opportunity to learn about it and to provide certain required notifications to parents. So there have to be postings about data breaches, and they have to include specific information, including contact information for the Federal Trade Commission, which is the federal entity that oversees compliance in the case of security breaches. So then also there are requirements that you also use a broader definition for breach. So it is a very broad definition. Any unauthorized acquisition of computerized data that might compromise the security, confidentiality, or integrity of covered information that is maintained by an operator or the district. It does not include good faith acquisition of personal information by an employee or agent of an operator or the district if that person has a legitimate purpose to do so. But otherwise, it is very broad as far as what is considered to be a breach. And each district also has to implement and maintain reasonable security procedures and practices that would meet or exceed industry standards for protecting covered information from unauthorized access, destruction, use, modification, or disclosure. ISB is required to create a guidance document for districts defining what reasonable security procedures and practices actually means. We don't have that yet, but that is going to come. Now, one thing to keep in mind is that there are some, I would say, protections in the law if breaches impact only a small portion of the student environment. So if a breach impacts less than 10% of the student enrollment, then the school district isn't required to disclose information about that breach. You may still want to, but it isn't required in the way described by the law. And also there are some limitations in the law that allow you to delay notification of a breach if a law enforcement agency says that if you notify people about it, it will interfere with a criminal investigation. So sometimes, you know, the FBI may be getting involved in some of these matters, for instance, and if they were to tell the school district, you know, we don't want you to notify people of a breach because we think it's going to impact our ability to identify the source or to address it, then the law does include some limitations that respect that authority.
Great. So Don, what should districts be doing now and thinking about regarding security and breaches?
Well, I think, you know, relative to breaches, in so much, I know at least for our organization, so much has moved to the cloud and the services that we're using that if something's going to get breached, such a high percentage of what we do is in the cloud. So it's not really our security as much as the security of the operator. So that really then, you know, boils down to being notified of such a breach. But I would think that a lot of districts are working with some security consultants. If you don't have the security staff on board, we use security consultants to help develop our plan. But for some of the hosted services that we do manage, for instance, we use Office 365 and we use the G Suite product. There are services that will actually, they'll monitor them for you, and you receive alerts if there's any type of suspicious activity, in addition to the alerts you might receive directly from Google or Microsoft on their products. Additionally, some of the services, the service that we use, it actually, there's some nice reporting features on what like extensions, Google extensions are being used by staff, and they actually have a level of a rating of those extensions, of which might be higher risk in terms of data privacy. I think the end result is that, and we're trying to prepare staff, is that there's going to be a lot of stuff that probably goes away that they might be accustomed to, because you also have when you're doing the discovery process of what is actually being used, some of these vendors, it could be very, very challenging in order to get them to agree to a data privacy addendum.
Yes, and one of the provisions in the new amendment is the option of schools having a privacy officer. Nicki, can you take us through the new provisions of having a designated privacy officer?
Yeah, and again, this is an optional part of the law. It says that districts may designate a privacy officer. It can be the same person that you designate as your records custodian under the Illinois School Student Records Act. Basically, they're charged with carrying out the duties and responsibilities of the act. It doesn't need to necessarily be a new person or a new role. It can be, you can expand someone's existing job responsibilities to encompass the role of privacy officer. I know that, and I'd be interested, I know Don's going to talk to this issue. One of the things that, is sort of foremost in my mind about SOPPA is that it really requires districts to get a handle on all the different ways that they're sharing student information, or vendors who are generating, with whom they've contracted where student information is generated. So students are, whether that's, the apps that teachers are using in the classroom setting that, are interactive with students, all the way up through your, student information systems, potentially your bus contractors, if they're getting information. There's just a whole myriad. Certainly, I know there's a question about Google in the chat. Certainly any of your Google, your education management systems, your technology management systems, all of those things would be covered. And so, one benefit certainly of designating a privacy officer would be that you have one person who's ultimately responsible and in charge of, whether you're using something like Education Framework, as Dawn talked about, whether you're doing sort of an in-house audit on all of these different contracts, someone who is sort of keeping track, if you will, of all of the requirements from sort of the beginning of the interaction with the vendor all the way through posting those contracts at the end.
Yeah, we've started our an audit process several months ago, but then something kind of happened in education where we kind of got distracted. We're kind of focused on some other topics right now, but the purpose is really to generate a means of which you have a listing of every service that's out there, who it serves within the district. There are going to be some services that are just they're servicing teachers only, and there's no student information being provided, but also then using it as a means to track where you are in the evaluation or reevaluation process or compliance with the upcoming law, to store. I'm using it to store all the contact information so we can do a mail merge and get notifications out to these online service providers more quickly and easily. And then also one thing, we just have set up a service account for an email account for it's his data privacy officer at District 96. Just so that we have one place for all that information to go, communications to go through, so nothing gets lost along the way. And it's going to be a year-long process, and it's just a matter of trying to stay on top of it. And yes, we did designate a data privacy officer in the district, and as I think with a lot of districts, it'll end up being the current director of technology.
Well, thank you. So there are a handful of other responsibilities that districts have related to creating policy, deletion of records, notices, how the law will work, and working with legal counsel on those various pieces. So Nicki, can you tell us about the policy and notice requirements?
Yeah, certainly. And I can take you through quickly the ones, all of these. The policy one is interesting. Each district has to create a policy for who can sign contracts with operators. So you have to basically designate who can be the signator on those contracts. And these are specifically operators with whom student information is shared or provided. One thing that, I know Don and I have talked about this quite a bit in the past, and I've done it with a few of the other districts around, which is, this, I think, is trying to prevent or prohibit the idea of teachers sort of agreeing to click wrap, agreements at the classroom level. So what a lot of districts have started to do, some are sort of well along this way, and some are sort of starting this process, is particularly those educational apps that teachers want to use. They've set up an internal process to vet them. Some use a service like Education Framework, some review the privacy policies themselves, others have us do it. But the idea is to create sort of a running list of the ones for whom the provisions in their privacy policies comply both with district practice and policy and of course state law now. And in that way, it's not, you're sort of circumventing the problem of everybody sort of, signing on to these agreements. So you have, the apps that are approved, ones that are not approved, and then the process by which educators can submit apps for review. And I think that's a really effective system. It also enables, I think when we first started with education technology, teachers were and educators on every level were like, this is great. There's all these free, amazing sources out there. We're just going to use them all. And I think both from a data privacy perspective, we've seen a sort of a pullback, which is good, but also from a education pedagogy standpoint. So a lot of these processes not only involve the director of technology, but they also involve the, assistant superintendent for curriculum and instruction, right? So you're vetting on both levels. So again, this is just, the policy has to state who can enter into these agreements, but here's a great way to think about, not restricting your teachers and giving them an access and an avenue to request the use of different online technologies. You had also mentioned so just quick, again, deletion of records. Districts need an avenue to do that with their vendors. The notice requirement was the other one that you mentioned. ISB is supposed to create a model notice. Again, they are very busy right now. I don't think that they have created it yet. They likely will before the implementation date. Basically, school districts will have to provide a notice to parents at the beginning of each year, which states in general terms the types of student information and data that's collected and shared with operators and the purpose of collecting the data and using the data. Again, and I know Jackie's going to talk a little bit later on about the new parent and student rights under this law. But Sarah, I think this really goes back to your description at the beginning of the sort of push to understand the value of these education technology tools, but understanding the real concerns that parents have about where their student data is going and is it being protected. So again, this notice requirement to parents, I think, flows directly from those concerns.
Absolutely. And Nicki, those are the requirements, the new requirements for districts. Are there any new requirements for operators?
Yeah, there are a few. Again, the bulk of this law in the past were operator responsibilities and duties, and those remain in place. They have, the amendments have added a couple of new ones. First, they've always been required to implement and maintain reasonable security procedures. And I know Jackie mentioned that ISB is supposed to come out with some guidance on that. Now there's an addition to that phrase in the law, and it says that the security practices and procedures of the vendors have to meet or exceed industry standards. There's also now a new clear notification requirement that they have to notify districts about any breach of information within 30 days of determining the breach occurred. A lot of our districts that we work with want 48 hours notice, and so a lot of you guys are already negotiating that into contracts, but this is a 30-day requirement. They also have to provide a list of third parties that they share information with. So again, those subcontractors, their hosting platforms and the like. And so those are the sort of some of the big ticket new items that operators are now going to have to comply with as well.
Yeah, and I will mention in the negotiations, there were operators like Google and Microsoft at the table in Springfield discussing these proposals. And Don knows that because of the work with EdRed and really understanding, like you said, Nicki, the district requirements, but also the operator requirements. But, Don, on that point, what has your experience been so far with operators being willing to adhere to SOPPA in general? And then also, do you have any concerns with these new requirements as it relates to what you're hearing from operators?
So far, I mean, I've gotten a handful of responses back, but we also haven't sent out all of them as of yet. So far, we have had some markups, but on the negotiable side. So I'm hopeful that since this is, I really see in terms of student data privacy, the laws just continue to get, stricter, increasingly strict across the nation, as opposed to it just being a handful of states that are doing it. I would hope that the online service providers will be compliant. They're having to already be compliant in other states with very similar guidelines in place. Why would they not do that for Illinois and moving forward? So hopeful that we don't have to discontinue a lot of services or being or needing to find replacements for existing services, over the next 6 to 8 months.
Yeah, in my experience on negotiating the handful of these that I've done so far, the companies, the vendors have been very amenable. In some ways, this makes our life easier because it lays out a law that specifically requires these things to be done. And I've absolutely had conversations, including since this shutdown began. I've had conversations with vendors where I've ended up on the phone with their attorney at their law firm in Washington, D.C., saying, well, you know, FERPA, those are just guidelines, and well, you know, there's no specific requirement in the law that you do these things. And I've been able to respond by saying, welcome to Illinois, that, you know, this contract is going to be in effect next year, and that as of next year, Illinois does require X, Y, and Z. And so we really don't have a ton of room to negotiate. And that makes it go down a lot easier than when we used to have to try to say, yes, although FERPA, you know, it might just be guidelines, and there were tons of them from the Department of Education available on their website. We were able to say, even though these were just guidelines, that we really think that the department expects them to be done, but we had to argue a little bit with them about it. We don't have to argue anymore on many of these facts.
Yeah, that's a really good point of one of the benefits of the legislation when it comes to working with those operators. So for the first time in SOPPA, we have a very specific student and parent rights. So Jackie, can you take us through those? And I will say that these are also another point that was very, very heavily negotiated, just to make sure that you understand the impact. You know, the vision and the intent is very good, but yeah, Jackie, I think walking us through the implications of this is very timely.
Right. I remember that this was definitely one that, because Nicki and I were both involved in helping in the background in some of the, you know, negotiations and the drafts of the law that occurred. And this was one that from the outset, we really identified, and I know EdRed identified, as being really burdensome in some ways for school districts and for vendors, because essentially, just to remind you, under FERPA and ISRA, students have always had the right, and their parents, if they're under the age of 18, the right to see information, review student record information. However, whether or not that granted the right to inspect information that was being used by a third-party vendor, we certainly didn't necessarily concede that fact, because it can be difficult to obtain the information from the vendor. It can be difficult to even just collect the information as the vendor. But the new law does give the right to a parent to inspect the student's covered information, to request a paper or electronic copy of the student's covered information, and to request factual corrections of inaccuracy in the student's covered information. And again, parents have always had the right to challenge information in student records, but what this law is doing is making it very clear that that right extends to data that is being held by a third-party vendor. There also are some limitations in the law that are student and parent rights that are really just reiterations of existing policy under FERPA and ISRA. So the law specifically provides that a student's covered information can only be collected for K-12 purposes, that a student's covered information has to be limited to only what is necessary for the K-12 purpose for which it is shared. Now, K-12 purpose is very broad. It does not mean that it's being collected by the school for, you know, education only. It can be being collected in order to allow for administration. It can be collected to allow for provision of other services. So it's very broad, but that does now codify the requirement that we already saw in FERPA guidance, that the real reason that this exception is allowed is to allow schools to do their jobs easier by using vendors to help them to do it. It's not to share student data with vendors so that they can use it for their purposes that are completely unrelated to the school. And the law does provide, it's important to understand that if you get a request from a parent to challenge the accuracy of information that's maintained on their student, that there are certain specific requirements that you must comply with. So it is a good opportunity to make sure that you're reaching out to counsel to make sure that you're complying with those requirements along the way.
Don, do you have any thoughts on parents and students and how districts can make sure that the parents in the community understand the issues surrounding data use and security?
You know, our game plan is really to put a communications plan in place. Once the policy goes in, gets adopted, we just went through the first reading of the actual, what is it, 7345. We just had our first reading on the new policy. And because it's going to be important to educate parents and educate staff on these changes. So we'll just use our different communications platforms to let them know, you know, what their rights are, reference the information on our website where they can find it. And if they have questions, again, they can contact that data privacy officer email address, and we can track everything through there.
All right, so thank you for that, Don. Now I want to take a couple of minutes at the end to allow, we have a number of questions that have been submitted and some of them have been covered, but open it up. Nicki, is there any questions that you want to address now that we've ended the presentation?
Sure, absolutely. And again, you know, we've sort of thrown a lot of requirements at folks on the phone. I mean, our goal here is to, we'll answer some of the specific questions that have been thrown our way, but our goal, again, is to give you guys a general sense of what this looks like for districts, and, you know, for Don to sort of talk through a little bit, as he has, about how this looks at the district level. There's a lot here, and the reason we're doing this on August 4th, 2020, rather than June of 2021, is that this is really going to be a year-long process for districts to try to come into compliance. You know, just the process alone of identifying where they share data with whom and how is going to be sort of crucial as a first step, and that is going to take some time. And again, there are some resources out there to help, but I do think there's going to be a lot of questions and nuance as this bill gets implemented, and as we sort of see how this works out. One question we got in that was, well, I think we covered the question. There was a question about Google, and certainly if you're using Google Apps for Education, the Google Suite, any of those, you are, of course, sort of interacting and sharing student data. There's probably student data being generated as well. So that would be covered by SOPPA. Those big, what we usually call sort of macro curricular, I think is the term we often use. So the micro curricular being those apps, but the macro curricular being, you know, your bigger ticket sort of Google contracts are certainly, you're going to want to make sure that they're compliant with SOPPA. And if those are coming up for renewal, again, looking forward and looking ahead. I did want to,
Nicki, can I just say real quick on Google?
Yeah.
I always tell people, you can't assume that any company is going to be in compliance just because of who they are, how big they are. I think there's a little bit of an exception when it comes to Google. I mean, I will say, like, we've looked at Google's things before for many clients. I think Google is probably going to be the closest you can get to just assuming that they probably are on top of this. They just have such a massive market when it comes to education that, you know, but again, it's definitely worth making sure, even, you know, but again, it won't probably require a ton of work, for instance, if you do that. But there, I think Zoom provides a really great example for everyone who recalls what happened with Zoom when we went remote in March, and everyone jumped on Zoom, and then people came out and said, wait a second, we don't think Zoom is compliant with FERPA. So you really can't assume just because it's the next big thing in education, you've got to do the steps of vetting and negotiating and you know, doing that work.
Yeah, absolutely. And we actually had a question come in about Zoom. It was actually in relation to what is the sort of definition of design for K-12 purposes. And as Jackie talked about, it's a pretty broad definition, but the question specifically was services like Zoom and databases that the public library offers to our students, which are not necessarily designated for K-12 use, are they not bound by SOPPA? And then later, the sort of addition to that question was, should we expect our public libraries to conform? And if we want to direct students to their online resources? If not, should we not promote those resources? So Jackie can weigh in as well. There's sort of a couple of different pieces of this. If I'm understanding the question correctly, there are some online resources that the library provides, their catalog and some, maybe access to some programming that you're just sort of suggesting, hey, this is a resource out there for students and parents. Short of any sort of agreement that you might have with the library, which would be a more complicated question, if that's what you're doing, you're just referring students to those resources, then there's not really any SOPA implications. The library obviously would be well advised to ensure that that if they're using any interactive platforms where students are engaging, that certainly they need to keep an eye on that. But if you want to refer students there, that's absolutely fine. In terms of Zoom, Zoom obviously has an education platform. If you are using Zoom as an educational tool, we would highly recommend that you either engage Zoom with the Zoom for Education program, which has a lot more privacy provisions, or you're negotiating a contract with Zoom. We could argue back and forth about whether Zoom is specifically being marketed for K-12 purposes. I think arguably it is at this point. And I think given the sort of focus right now on remote learning, you're going to want to make sure that whatever platforms you're using for remote learning are secure and safe. And actually, one of the other questions was, how is remote learning affecting SOPA compliance? I'm not certain how to answer that other than to say, amidst all of the turmoil and every other question that districts are looking at and dealing with, we would highly encourage that, that someone in the district is looking and working with us or your other legal counsel on ensuring that whatever tools you're using are secure and that the student data privacy is secure. There's going to be obviously a huge uptick in use of these resources as districts either move completely remote or hybrid. And so, the time is now to make sure that you have a process in place to look at these products, to vet them. We are seeing wonderful education technology companies that are fully coming into compliance with state and national laws on this stuff. And those are the ones you're really going to want to focus.
I also think that, what's important to keep in mind with remote learning is, I think it's the same thing that we're keeping in mind across the board when it comes to regulatory and legal requirement, is that we were given, I think, a little bit of a grace period, grace in the way that, we traditionally use that term, that we asked for grace from parents. We asked for grace from regulators. When this all first happened, we said, we are just doing our best. We're trying to just keep kids, engaged. And we're going to maybe we did use Zoom even before it was compliant. And, I think that was very reasonable, and we worked with schools that took that approach, but that is over. I mean, that is over, just like it is with every other type of legal mandate that is on schools, and there are many. And that's to say that I think going forward for the fall, that the expectation from the Department of Education, the expectation from the courts, the expectation from parents and the media is going to be that you are robustly protecting student data, and that grace period is over. So I would not assume that even if we are on full remote and we're still struggling to figure out how to do that, I think we do have to make sure that we're taking these steps regardless of the.
Yeah, I would definitely agree with that. We had a couple of sort of technical questions that I'll say that came in, Sarah, so I'll try to hit those too. We mentioned having a policy on who can be a signatory on contracts. Do you need a Board of Ed policy? Yes, we need a Board of Ed policy. I'm assuming that ISB is going to come out with something. Jackie and Sarah, you might have a better update on that. But I assume that they'll also be taking time because they are also crazy right now.
I think that's right. I think, they've got their hands full over at ISB, at press. They are working on so much right now, and this isn't due until next year. And also we had a question about, how do we define reasonable security measures? Well, the ISB guidance that's going to be issued is going to be a real key for us there. I mean, we also are being directed by the statute to look at what is the norm in the IT community, and folks like Dawn are going to be the experts to know within your district, what those norms look like. But we are waiting for ISB, and I think ISB is understandably going to be waiting for ISB to see what ISB puts out as far as guidance before they are going to give us anything. That's my understanding.
Yeah, and we just got a question as to whether we believe the July 2020 date, 21 date will stick with COVID issues. I don't know, Sarah or Dawn, you guys were sort of most involved in the legislative process. I'm not holding my breath for anything, but I wonder what your thoughts are.
I personally, I thought, I have been thinking along the same lines. Will they push it back, in light of everything that is going on? And even if it's just due to the fact that districts are having to really change the way they operate and being able to put the time and energy and effort into implementing the new law, or if they, even if it's an additional 6 months or, to the following year. But I wouldn't be surprised if that did happen. And I think it would help a lot of districts. The other thing I do want to say really quick is while I think for a lot of tech directors, this work is going to fall on them to manage it. What we've tried to do here is really make it a team responsibility. It's not just tech. When it comes to authorization or approval of resources, everything is going to go through our cabinet team. The only individuals that can authorize contracts are going to be our superintendent and our directors. So just to be able to share the responsibility and the load, and also so that everybody in each of those areas do understand exactly what the implications are of the law and take it as serious as it needs to be.
And I just want to comment on the implementation date. I will say that I think for all other bills that were passed and we have a July 2021 and January 2021 implementation date, I would agree. This is, and I think similar to Jackie and Nicki's point, this is different in that it's so much more relevant now than it has ever been. I think it's really going to be, communicating and understanding the impact of the implementation and how much it takes. But I'll tell you that it really kind of depends on what the next 6 months look like, and not so much with COVID, but with regards to how schools are going to be using all of these new platforms and contracting with vendors and operators, and if there's an argument to push that back, because I think this is the future and it's being used. I mean, even this week, as many of the people who are tuning into this know, even districts who have been committed to a hybrid plan for 6 weeks are flipping to do all remote. And it really, similar to what Jackie said of being given grace, is districts in this area of student protection aren't going to be. So I'm not as confident that they'll push this implementation date back, although it continues to be a priority of EdRed and all the management organizations, just to really make sure that legislators and the agency understand everything that's on the plate of schools right now, as we look into beyond the next 6 months and full year.
So I think we're almost at the end of our time, but I would love to just grab this one last question, which is, how will a district receive a SOPPA certification from the AG's office or from us? There is no sort of system to sort of, deem you SOPPA compliant. However, we are more than happy to help you both with, as we talked about, data addendums or data contracts, but also to sort of look and help you sort of think through systematically how to start implementing and how to get a handle on this law. So we're happy to help assist you through this process. Jackie and I talked to a lot of you guys. I know a lot of your tech directors, and we're happy to do so for this. we haven't seen anything come out from any the AGs or otherwise or ISB talking about certification. But I think if you, if you implement with fidelity, you're going to get to where you need to be with this. Again, hopefully this year coming forward will allow you a little bit of that space to do so.
Yeah, and I just want to say a huge thank you to Sarah and Dawn for joining us, not just for this specific conversation, but for this conversation generally over the past couple of years, as long as we've been, working through this. It is amazing to have such an amazing team and network in Illinois of people who are thinking about these questions, because we can't answer them in a vacuum from just the legal perspective. So it's so great to have the legislative partnership and the practical partnership that we've had with you guys, and we look forward to it going on for a very long time.
Well, thank you for your support and partnership too.
All right, well, I think we are out of time. As Jackie put in the chat, someone asked about the recording. This will be, the link will be sent out. You're welcome to share this with anybody in your district or with your pals who are tech directors at other districts or superintendents or whatnot. We really appreciate EdRed's partnership on this webinar, and I'm sure we'll be talking about these issues going forward, but hopefully this sort of immediate introduction was helpful to you all.
All right, thank you everyone. Have a great day.
Great day.
Bye.